What if I told you the family immigration process you have been relying on for years is about to change dramatically? Thousands of families across America are waking up to a new reality that is forcing them to reconsider their immigration plans and timelines. Bringing their loved ones to the United States just got significantly more complicated, and the implications of these changes will be felt for years to come by families who have been waiting patiently to reunite with parents, children, siblings, and spouses. In January 2026, the Trump administration announced major changes to I-130 family petition rules that could affect your ability to sponsor parents, siblings, spouses, and children through the family-based immigration system. If you have a pending petition that you filed months or years ago, or if you are planning to file one in the near future to bring your loved ones to join you in the United States, the next few minutes could determine whether your family stays together or remains separated for years to come. The information I am about to share with you is critical for anyone who depends on the family immigration system, and understanding these changes now rather than later could make all the difference in your immigration journey. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now let us get into the video. Hello everyone, welcome to US Immigration Info, your trusted source for the most important updates on American immigration, visas, and policy changes that directly impact your future in the United States. Today, we are breaking down the latest announcement on family-based immigration and the I-130 petition process. These changes are expected to take effect in early 2026, and if you do not understand what is happening, you could face massive delays, denials, or even long-term separation from your family members. Watch this video until the very end. Take notes and please subscribe to US Immigration Info so you never miss an important immigration update that could change your life. Let me start by explaining what the I-130 petition is and why it is so critical to family immigration in America. The I-130, officially called the Petition for Alien Relative, is the foundation of family-based immigration to the United States. This is the form that U.S. citizens and lawful permanent residents file with USCIS to establish a qualifying relationship with a foreign family member. Once the I-130 is approved, it confirms the relationship is valid, and your relative can then apply for an immigrant visa through consular processing or, if eligible, adjust status inside the United States to become a permanent resident. The I-130 covers different family relationships, including immediate relatives like spouses, unmarried children under 21, and parents of U.S. citizens, as well as preference categories for siblings, married children, and adult children. For decades, family reunification has been a cornerstone of American immigration policy. Millions of immigrants have used the I-130 process to bring their loved ones to America legally. But in January 2026, major policy changes were announced that are reshaping how these petitions are processed, evaluated, and approved. These are not minor technical adjustments. These are significant shifts that reflect a broader enforcement-focused approach and an effort to reduce overall immigration numbers, particularly in family-based categories. First, there is significantly increased scrutiny and heavier documentation requirements for I-130 petitions. Under the new guidelines, USCIS is requiring petitioners to submit substantially more evidence to prove the legitimacy of family relationships. In the past, basic documents like birth certificates, marriage certificates, and proof of the petitioner's citizenship or permanent residency were often sufficient for straightforward cases. Now, under what is being described as enhanced vetting, even routine I-130 petitions may face much more intensive review. USCIS may ask for extensive documentation of the relationship history, stronger proof of financial interdependence for spousal petitions, detailed affidavits from third parties, photo evidence spanning the full relationship timeline, and in many cases, certified translations of foreign documents from approved translators. In practical terms, preparing an I-130 petition becomes more complex and more expensive. Many people may feel they need an immigration attorney or a qualified professional to help compile the evidence correctly. You may need paid document translations. You may need affidavits from friends, family members, and colleagues who can attest to your relationship. And even after submitting all of this, processing times may rise because officers will spend more time reviewing each petition. Cases that used to be approved in 6 to 12 months may now take 18 months or longer, and that is only the I-130 stage, not the entire immigration process. The enhanced documentation requirements mean that petitioners must gather years of evidence showing the genuine nature of their relationships. For spousal petitions, this includes joint bank statements, shared lease agreements, utility bills in both names, photographs from various stages of the relationship, and detailed affidavits from people who have witnessed the relationship develop over time. Second, there are stricter financial requirements for sponsors. When you file an I-130 petition, you are not only proving a family relationship, you are also committing to financially support your relative, so they do not become a public charge in the United States. This is typically done through Form I-864, the Affidavit of Support. Under prior standards, the sponsor's income requirement was commonly based on 125% of the federal poverty guidelines for the household size. If you did not meet the threshold, you could often use a joint sponsor. Now, the financial standards are tightening. Proposals indicate the income threshold could increase to 150% or higher. The use of joint sponsors may be limited, making it harder to qualify if you personally do not meet the income requirement. Assets may be scrutinized more aggressively, and having assets may not be enough to overcome an income shortfall unless you can prove they are liquid and readily available. Here is what that means for real families. If you are a U.S. citizen sponsoring only a spouse, you might currently need around $28,000 per year, depending on the guideline chart and year. If the threshold moves to 150%, that number could jump to roughly $33,000 or more. If you are sponsoring multiple family members, like a spouse and parents, the required income rises quickly. For a household of 4, you could be looking at $50,000 or more annually. Many American families simply do not earn that much, especially in lower-wage industries. The result is that working-class and lower-middle-class sponsors may find it much harder to bring loved ones through family-based immigration. This creates significant barriers for families who have genuine relationships and genuine ability to support their relatives, but cannot meet arbitrary income thresholds on paper. Third, there are expanded grounds for denial and increased use of requests for evidence, also known as RFEs. An RFE is a notice from USCIS asking for additional information or documentation before they make a decision. The rate of RFEs has increased, and under the new 2026 approach, USCIS officers may have broader discretion to question the bona fides of relationships and deny petitions based on concerns that can feel subjective, such as whether a marriage seems genuine, whether family ties appear strong enough, or whether the petitioner has shown enough commitment to supporting the relative. The administration is also pushing USCIS to take a harder line on inconsistencies, even small ones. A minor date error, a different spelling of a name across forms, missing a prior address from years ago, issues that might previously have been corrected easily can now trigger RFEs or even denials. The message many families are receiving is that the process is being made more difficult, more expensive, and more stressful, which may discourage people from applying at all. Officers are being trained to look for any inconsistency or gap in documentation that might suggest the relationship is not genuine. Fourth, there may be more difficulty for family preference categories due to the priority date system and visa bulletin retrogression. Family preference categories are limited by annual numerical caps, which creates backlogs, especially for countries with high demand like Mexico, the Philippines, India, and China. Your priority date is the date USCIS receives your I-130, and that date determines your place in line. You can only proceed with the immigrant visa stage or adjustment of status when your priority date becomes current, according to the monthly visa bulletin. Under the current direction, many are seeing deliberate slowdowns in how quickly priority dates advance. So even if your I-130 is approved, you may still wait years longer before your family member can actually immigrate. In some sibling categories, wait times already exceed 20 years for certain countries, and under slower movement, those waits could stretch to 25 or even 30 years. This means that families who file petitions today may not see their loved ones for decades, and some may never reunite within their lifetimes. Fifth, there is increased scrutiny of adjustment of status applications, including cases involving immediate relatives already in the United States. Many people file I-130 petitions for spouses or children who are already in America on tourist visas, student visas, or sometimes with complicated status histories. Historically, immediate relatives of U.S. citizens often had more options to adjust status if they met requirements, even if they had certain prior issues depending on the facts. Under the new approach, USCIS is taking a stricter view of overstays, unlawful presence, and suspected fraud. Even immediate relatives may face longer processing times, more interviews, more investigation, and higher denial risk. For example, if someone entered on a tourist visa and then married a U.S. citizen shortly after, USCIS may suspect misrepresentation and may investigate the case more aggressively. Officers may look for any reason to deny, including gaps in documentation, minor violations, or anything they interpret as fraud. Let us talk about how these changes can affect specific family categories. If you are a U.S. citizen sponsoring a spouse, you should expect heavier evidence requirements to prove the marriage is real, more in-person interviews, and detailed questioning about your relationship, daily life, finances, and plans. They will be looking for inconsistencies. You will need to demonstrate that your marriage is genuine through extensive documentation of your shared life together. If you are a U.S. citizen sponsoring parents, you may face the same enhanced documentation and financial review and any prior immigration issues your parents may have. Previous overstays, unlawful presence, old denials could be examined more critically. Parents with complicated immigration histories may face particular challenges, even when the underlying family relationship is genuine and unquestionable. If you are a lawful permanent resident sponsoring a spouse or unmarried children, the situation can be even more challenging because you are in preference categories with longer waits. USCIS may also scrutinize whether you are properly maintaining your own permanent resident status. Any issues with extended travel outside the United States or failure to file taxes could affect your ability to sponsor relatives. For siblings of U.S. citizens, the category is already the slowest, and there has been discussion about eliminating it altogether. Even if that would require Congress and has not happened, the fact it is being discussed shows the direction of policy. Families hoping to reunite with brothers and sisters face the longest waits and the most uncertainty about whether the category will continue to exist. Now, what can you do to protect your family's immigration prospects? First, if you are planning to file an I-130 petition, file as soon as you can. Your priority date is locked in on the day you file, and every month you wait can add more time to an already long process. Filing early establishes your place in line and protects you against future policy changes that might make the process even more difficult. Second, prepare the most complete and well-organized petition package possible. Do not submit only the minimum. Include strong evidence of your relationship, detailed affidavits, photos, communication records, and where relevant financial documents showing joint accounts, shared responsibilities, or genuine interdependence. A thorough initial submission reduces the likelihood of receiving an RFE and speeds up the overall process. Third, seriously consider hiring an experienced immigration attorney. With higher scrutiny, professional guidance can help you avoid mistakes, identify weak points before USCIS finds them, prepare for interviews, and respond properly to RFEs. The cost of professional assistance is far less than the cost of a denied petition or years of additional delay. Fourth, make sure you meet the financial requirements. Review your income carefully. If you are close to the threshold, plan early. If joint sponsorship is still an option in your situation, line it up in advance. If you plan to use assets, be prepared to prove they are liquid, accessible, and properly documented. Gather tax returns, pay stubs, employment letters, and bank statements well before you need them. Fifth, be accurate and truthful on every form. With stricter review, false statements or material omissions can lead to denial and potentially serious consequences. Even honest mistakes can create delays, so triple-check every detail before submitting. Have someone else review your forms before submission to catch errors you might have missed. Sixth, if you receive an RFE, respond quickly and thoroughly. You may have only 30 to 60 days. Provide everything requested. Address each concern directly. And if you are unsure how to respond, get legal help immediately. A poorly prepared RFE response can result in denial, even when the underlying case is strong. It is also important to understand your rights. If your I-130 is denied, you may have the option to appeal or file a motion to reopen or reconsider, but these steps are time-sensitive and technical. In some situations, it may be better to correct the issues and file a new petition rather than appeal. The best choice depends on the facts of your case. So, legal advice matters. Also, stay informed. Immigration policy can change quickly, and rumors can seriously damage cases. Follow reliable sources like U.S. Immigration Info, where we break down changes clearly and explain what they mean for real people. Do not rely on unverified social media posts or someone told me advice. Accurate information from official sources is your best protection. If you filed an I-130 before these standards took effect, understand that USCIS may still apply updated scrutiny to pending cases. If you get an RFE asking for more evidence, that can be the new approach showing up in your case, and you must respond strategically. Be prepared to provide additional documentation, even for petitions filed under earlier, less demanding standards. And remember, family-based immigration is not the only path. Depending on your situation, you may want to explore employment-based options, the diversity visa lottery, humanitarian pathways, or other lawful strategies. Each has its own requirements, but it is worth understanding all possibilities. A qualified immigration attorney can help you evaluate which pathway offers the best chance of success for your particular circumstances. Let me also warn you about common mistakes that have become even more costly under stricter rules. Rushing the petition and submitting a weak package, hiding or failing to disclose past immigration violations, not maintaining legal status while a petition is pending when required, and failing to update USCIS about address or major changes can cause you to miss important notices. Each of these mistakes can result in denial or significant delays. The overall approach we are seeing represents a major shift away from family reunification as the central principle. Whether you agree or disagree, understanding the direction matters because it helps you plan realistically. If this direction continues, you should expect continued tightening, more enforcement, and more obstacles in the family-based process. I want to be honest, these changes can make family immigration significantly harder. Many families may face longer separation. Some petitions that might have been approved in the past may face denial now. Financial barriers may block some sponsors entirely. That is the reality many are facing in 2026. The system is becoming more restrictive, and families must adapt their strategies accordingly. But do not lose hope. Thousands of families still succeed every year. With careful preparation, strong evidence, patience, and good legal guidance, it is still possible to reunite legally. It may require more effort, more documentation, and more time, but it can be done. Families who approach the process with thorough preparation and realistic expectations continue to achieve their immigration goals. Here on U.S. Immigration Info, we are committed to helping you understand these changes and make smart decisions. We will continue monitoring policy updates, breaking down new announcements, and explaining what they mean for you. Our goal is to provide you with accurate, timely information that helps you navigate this complex system successfully. If you found this video helpful, Hit the like button and share it with anyone going through the family immigration process. Subscribe to U.S. Immigration Info and turn on notifications so you do not miss the next update. Policies can change quickly, and staying informed is one of the best protections you have. Drop a comment below with your questions or tell me what topic you want next. I read the comments and your feedback helps me create content that addresses your real concerns. Your questions help us understand what information our community needs most. Remember, knowledge is power in immigration. The families who succeed are the ones who understand the rules, prepare thoroughly, and act strategically. If you are planning to sponsor a family member, start preparing now. Gather your documents, review your financial situation, and if needed, consult with an immigration attorney. The sooner you act, the better your chances. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video. Stay informed, stay prepared, and do not give up on bringing your family together. Take care.